Okay, without much further ado, I think I'll hand over to 20 Essex and their panel on re-examining the landscape for challenges to arbitration awards. Thank you very much.
Good morning, ladies and gentlemen, and welcome aboard this delayed 11:10 service to the exotic and not often travelled land beyond the arbitration award. We have a scheduled travelling time of 50 minutes and a revised disembarkation time of about 50 minutes from now. We will be accompanied on our journey by 4 expert practitioners and commentators whom I will introduce in just a moment. Each of them will share insights into recent developments of the law and practice concerning different forms of recourse against an arbitration award. It ain't over till it's over. It's the sort of topic normally reserved for one of the later sessions in the afternoon, so we're grateful to the organisers for scheduling a slot whilst there is still so much caffeine-fuelled energy in the room, at least on the part of the panellists. A brief reminder of the landscape. We're concerned with a code of provisions found in sections 66 to 71 of the Arbitration Act 1996 under the heading Powers of the Court in relation to award, and principally sections 67, 68 and 69. And you'll find printed copies of those provisions amongst the materials as a handout on your tables, and many of you will be familiar with the text, I have no doubt. Section 67 concerns the right of a party to challenge an award on the ground that the tribunal lacked substantive jurisdiction over one of the parties or the subject matter of the award. Section 68 deals with challenges to an award on the ground of serious irregularity affecting the tribunal, the proceedings, or the award, with the important proviso that such serious irregularity must be found to have caused or will cause substantial injustice to the applicant of a kind falling within the categories adumbrated in section 68(2), and those are set out in the handout. Section 69 sets out the test for appealing to the court on a question of law arising out of an award unless otherwise agreed between the parties, for example by adopting a set of arbitration rules that exclude such rights of appeal. Sections 70 and 71 deal respectively with certain procedural aspects and the effect of a successful challenge or appeal, and sections 67, 68, 70 and 71 are mandatory provisions of the Act, and as just noted, section 69 may be excluded by agreement of the parties. In terms of the philosophy underlying these provisions, it's perhaps worth reminding ourselves what's been said about section 68 in particular. And in his judgment in Reliance Industries, Mr. Justice Popplewell, as he then was, recalled the language of the report of the DAC when the arbitration bill, as it then was going through Parliament, saying that the court does not have a general supervisory jurisdiction over arbitrations. The parties have chosen arbitration rather than litigation, and Section 68 is designed as a long stop, only available in extreme cases where the tribunal has gone so wrong in its conduct of the arbitration that justice calls out for it to be corrected. And we'll examine in the course of the next few minutes whether that test is still fit for purpose, whether it has been properly and consistently applied, and whether we have struck the right balance in the English Act, at any rate, between the requirement of the parties for finality and party autonomy and the correction or safeguarding of due process rights. Our panellists are as sitting alongside from me, Kate Parlett, a barrister at 20 Essex Chambers, Charles Kimmins QC, also a barrister at 20 Essex, Mefanui Wood, a very experienced practitioner with knowledge of a number of different jurisdictions, now a partner at Ashurst in London, and Shap Salah, a very experienced arbitration specialist, also with the a partner in the specialist disputes practice in Tenier in Paris. So we're in good hands. Who on earth am I, you might be wondering? My name is Nigel Rawding, an arbitration member of 20 Essex, practicing entirely independently of Kate and Charles, having spent what seemed like half a lifetime at Freshfields, because it basically was. Kate, I think you're going to talk us through some of the recent examples of court decisions affecting Section 68 in particular.
Thank you, Nigel, for that introduction, although I have to say that was fairly ominous that you already started to distance yourself from our ideas. I want to address two questions. First, does a serious irregularity really need to be very serious? What do the recent cases show us about how bad it needs to be to make a successful challenge under Section 68? And second, what about procedural decisions? Is there scope for challenge of these in light of recent cases? As Nigel has just reminded us, Section 68 of the Arbitration Act allows a party to an arbitration to apply to the courts to challenge an award on the grounds of serious irregularity. A successful applicant under Section 68 must demonstrate a serious irregularity falling within one of the categories under Section 68, paragraph 2, and that the irregularity has caused or will cause substantial injustice to the applicant. In practice, it's generally accepted that it is only in rare and extreme circumstances that a Section 68 challenge will succeed. The courts are very reluctant to interfere with arbitral decisions unless the irregularity is very serious indeed. Recent cases suggest that breach of natural justice is still a fertile, possibly the most fertile ground for challenges. The key point will often be whether there is a critical finding relating to an issue that was in play, so that the parties had an opportunity to address the essential building blocks of the tribunal's ultimate decision. That point was made very clearly in the decision of Mr. Justice Bryan in the Commercial Court in June this year in PBO against Dompro and others. The dispute between the parties there arose out of a series of agreements for the sale and purchase of cocoa beans. It was decided in an arbitration under the Federation of Cocoa Commerce arbitration rules, which one might not know existed before you'd read this case. The dispute was initially heard by a first instance tribunal, which found against the claimant, PBO. Under the applicable arbitration rules, PBO could then appeal to an appeal tribunal in fresh proceedings, but that appeal tribunal also found against PBO, and PBO then brought 3 challenges under Section 68. 2 of those challenges concerned aspects of the decision that PBO argued that the parties had not had the opportunity to address. The first was the tribunal's decision that 11 of the contracts which formed the basis of PBO's counterclaim had been cancelled because PBO had displayed an intention not to perform them. And the second was the tribunal's finding that it did not have jurisdiction to deal with PBO's claim relating to further losses arising from the purchase of jute bags for the delivery of cocoa, which were ultimately not required because the cocoa was not delivered. There had been no submissions from the parties on either of those points, nor had the tribunal invited the parties to address them. Mr. Justice Bryan upheld the Section 68 challenge on both points. Concerning the cancellation of the contract, he held that the essential building blocks of the tribunal's decision were matters that the parties had not put in issue before the tribunal and on which the tribunal had not asked to be addressed. This was a serious irregularity within the meaning of Section 68. Likewise, concerning the absence of jurisdiction over the jute bag losses claim, jurisdiction had not been raised as an issue by either of the parties, and the appeal tribunal had not provided the parties with an opportunity to address it. On both issues, Mr. Justice Bryan was satisfied that had the parties been given the opportunity to address the tribunal on those issues, this may have resulted in a different conclusion and produced a significantly different outcome. Thus, both limbs of the Section 68 serious irregularity test were met and the Section 68 challenges succeeded. The same question of whether an issue was in play was addressed by the Privy Council in April this year in RAV Bahamas against Therapy Beach Club. This was an appeal from the Court of Appeal of the Bahamas under Section 90 of the Bahamas Arbitration Act, which is materially identical to Section 68 of the English Arbitration Act. The underlying dispute concerned property. Therapy Beach Club had leased land from RAV for use as a restaurant and beach club, and it alleged that it had been wrongfully evicted. Its claim was upheld, and the arbitrator assessed damages for consequential losses at $12 million, on the assumption that a renewal option under the lease would have been exercised. He also applied two discounts, a discount of 1/3 on the basis that part of the claim had failed, and a further discount of 15% on the basis that the claimant's experts' figures on damages were not supported by the documents. RAV challenged the award, alleging two serious irregularities. The first was that the tribunal assessed damages on the basis that the lease had not been renewed and it had not taken into account RAV's arguments about that. And second, it applied discounts which were not canvassed with or addressed by the parties. The board upheld the challenge, finding that there were serious irregularities in both findings. So the arbitrator had failed to address RAV's arguments with respect to renewal of the lease, and the basis of the 1/3 discount that the arbitrator had applied was only revealed to the parties when it appeared in the award. It had not been discussed by the parties or the arbitrator otherwise in the proceedings. But concerning the 15% discount, the board found that this had been brought into play by the claimant's expert evidence, so it could have made submissions on that issue. These recent cases affirm that the threshold remains high for a successful Section 68 challenge. But they also make clear that tribunals need to fulfil their obligations to accord the parties with a full and fair opportunity to make submissions on issues that form the basis of the award. That issues must be in play if they are to form an essential part of the tribunal's decision. Has this affirmation of the high threshold had an impact on the frequency of Section 68 challenges? There is some support for saying yes. Since the court year 2017 to 2018, there has been a significant reduction in applications made under Section 68, from 71 applications in that year to 19 applications in 2018 to 2019 to 16 applications in 2019 to 2020. It's been suggested by the Commercial Court User Group that this might indicate an increasing acceptance among applicants of the low chances of success of such applications. But the rate of success, which is difficult to discern because they're not consistently reported, remains low. So in 2019 to 2020, only one of the 16 challenges under Section 68 was successful, although in the following year of 2020 to 2021, there were at least 3 successful applications that we know of so far, so it seems it's difficult to read much into what we know of the success rates. Another issue that has emerged which has resurfaced really in a recent case, is the extent to which procedural decisions, and in particular case management decisions, can form the basis of a Section 68 challenge. In the ordinary course, it will be very difficult to establish that a case management decision meets the seriousness threshold to qualify under Section 68. But in PBO against Donpro, as I mentioned earlier, there were 3 challenges. The third concerned a case management decision, the appeal tribunal's refusal to allow PBO to amend its statement of case on appeal. Now, in addressing this challenge, Mr. Justice Bryan distinguished between case management decisions addressing discrete matters, such as costs and timetabling, and matters that may be determinative of the arbitration itself, in which the tribunal's duties under Section 33 of the Arbitration Act are consequently in sharp focus. The latter matters are more likely candidates for a Section 68 challenge. In respect of the refusal of PBO's application to amend, the Appeal Tribunal had made no attempt to identify the amendments. It had made no attempt to identify the applicable principles in relation to whether amendments should be allowed, to consider the potential prejudice to PBO in not allowing the amendments, or to consider the likely delay to the parties in allowing the amendment. That was sufficient, Mr. Justice Bryan held, to establish a serious irregularity, and one which met the substantial injustice threshold because the amendments could realistically have had a significantly different outcome on the case. This decision underlines the need for tribunals to carefully consider the merits of procedural applications and to provide appropriately reasoned decisions, particularly where a single case management decision could realistically lead to a significantly different outcome in the arbitration. Now, in PBO, there was a final award of the Appeal Tribunal, and the form of the decision may matter, since only awards can be challenged under Section 68. This requirement was confirmed in the 2019 decision of Mrs. Justice Cockerell in the Commercial Court in ZCCM Investment Holdings. There, the applicant had sought to challenge the tribunal's refusal to allow it to pursue a derivative claim. The refusal was addressed in a 22-page ruling, not in a final award. Now, the Section 68 challenge there was rejected on the basis that the ruling was not an award. It was of a procedural nature. It was insubstantial compared to the type of document that one would expect for an award in a complex multi-billion-dollar arbitration. Should the form necessarily matter? Well, one can see an argument that what should matter is the decision itself, whether it has the potential to be determinative of the arbitration, that's more important than its form. But that question of impact is very difficult to assess at a preliminary stage, whereas the impact of the decision should be very apparent by the time of a final award, and it should also be apparent by the time of a partial or an interim award that addresses the particular issue in play between the parties. In my view, it will ordinarily be very difficult to assess the substantial injustice point at a preliminary stage, and so it does seem to make practical sense to limit Section 68 challenges to awards. Many thanks for your attention.
Kate, thank you very much. Charles, knowing how high the hurdle is you have to jump over, you're going to tell us, I think, about a few practical do's and don'ts and some traps for the unwary.
Yes. Thank you, Nigel and Kate. Let's assume you are in the rare and wonderful position of being able to get one of these challenges up and running. You can extract a couple of tips, frankly, from the recent authorities to make sure that you don't mess up the next stage of the process. First of all, get your documents in order and get them issued in time. Now, there are two recent cases which touch on this called Orascom and T&V. They're on the slides behind me. In the olden days, we all did it. We used to stick in a claim form which simply said, "See witness statement attached." That was given the big no-no by Mr. Justice Andrew Baker in the Orascom case. And he said, no, it's got to serve in effect as a pleading. So you need to get all your ducks in a row and plead it properly in the claim form. And the witness statement must be for evidence and evidence only. And his decision was upheld in T and V and W by Mr. Justice Mayles, who said, yes, that's the right approach. Gone are the days where we do it in a witness statement. The next point, and I mentioned this briefly, is there is a recent case called RAV Bahamas, where the Privy Council said that it's good practice for a claimant to expressly plead, and indeed for the judge to expressly consider and deal with the issue of substantial injustice. But the court found in that case it wasn't necessarily fatal if you failed to do so, because often the concept of substantial injustice is inherent in the irregularity. But bear those 2 points in mind when you're getting your documents together. Get it in the right form and get the content right. Now, assuming you've got over that hurdle, don't miss the 28-day deadline for issuing the challenge. Now, there are many areas of law where it's quite easy to get an extension of time if you miss the deadline. This is most certainly not one. You have 28 days, and you can apply for an extension under Order 62, Rule 9, but it is very, very difficult to get it. There are literally a handful of cases. Essentially, your failure to adhere to that deadline must be properly something that was out of your hands. And there's been a recent spate of cases where people have tried all sorts of other arguments and they have been given short shrift. I've listed some of them on the slide, which you should see behind you. Everybody has to adhere to the same high standard. So let's take some examples. A case, funnily enough, I was involved in. One of the parties said, we are a very hierarchical company. It takes a lot of time to get things done. Therefore, we missed the deadline. In effect, relying on bureaucracy and red tape, and lots of very nice witness statements to the effect that things happen slowly for my company, and there's nothing I can do about it. It's the nature of the business. The courts say, no, not good enough. You've got to get everything ready in advance. So that will not avail you as an excuse. Another one, we are a state entity, and there's been a recent change of government. This caused us difficulties, and we missed the deadline, another case I was involved in. Now, again, the court said, no, not good enough. You may well be a state entity. You may well have a change of government, but everybody knows when the elections are coming. You work it out in advance. If as soon as you get notice that the award is coming out, you immediately get your ducks in a row. That's essentially what the courts say. So you will get no sympathy if you run that type of argument. And lastly, and it's perhaps less surprising that this one fell on fallow ground, we are a state entity funded by our citizens. We should be given a bit more latitude. Answer, no. And firmly, no. That one didn't work either. Just as an aside, COVID. Many people have tried the COVID excuse in these cases as well. And the court will need very precise evidence that I was wanting to do this on a particular day and I couldn't because of a particular COVID issue. It has to be specific. You cannot simply bleat that COVID has caused you problems. So that's the 28-day deadline. The other area I wanted to touch on, because it has been the subject of a lot of recent cases, is confidentiality. And the point I want to make is don't bank on the judgment, which the judge will hand down after the Section 68 challenge has been decided. Don't bank on that judgment being confidential. Now, the law here goes right back to a bankers' trust case in 2004. And they set down the following rules. Essentially, arbitration may be consensual, but an arbitration claim is not. You are no longer in the ambit of consensual proceedings once you issue an arbitration claim. And once you are in court, the public must be able to scrutinize court proceedings. Judgment should be given in public where this can be done without disclosing confidential information. And public judgments are particularly desirable when they cover points of law or practice. So 4 general principles from that case back in 2004. Now, the old approach in applying those principles was as follows. The courts were generally quite generous to those seeking to maintain confidentiality. Judgments were, in my experience, quite often handed down in private. Arbitrators' names were almost always redacted, even if that was the only thing which was redacted. Parties' names were often redacted, and confidential information was often excluded. But that was the old approach, and what I've noticed, looking at some of the more recent judgments, is the court has hardened in its approach to this, and this is why you must warn clients, in my view, that if you mount an appeal, that judgment may well become public. So, the test is essentially the same, but the courts do seem keen to promote the idea of open justice. And some people might say possibly at the cost of arbitral confidentiality. So there is a heavy burden, this is what the courts have emphasized recently, a heavy burden on a party seeking to maintain confidentiality. Once you've issued your Section 68, you and the judge are discussing what to do with the judgment. The judge will say to you, listen, it's all about public scrutiny, and therefore you must have a very good reason to maintain confidentiality. And you see words to that effect from Lord Justice Mayles in the Manchester City case. He also makes the point that English law wants to be seen as a law which makes it tough to appeal under Section 68. And that's the reason why it's in English law's interest to publicize these judgments. Look how tough we are. That's essentially the rationale behind it. Second point under the modern approach is if the award is in the public domain, and it often will be if there are enforcement proceedings elsewhere, then the judgment is likely to be made public and without reduction or anonymization. So none of those. And there are a number of cases I've put on the slide which are recent examples of that. Another sea change, and this will be important to all the arbitrators out there, identity of arbitrators will only be kept confidential in the rarest of cases. And as I mentioned earlier, in the old days, even when the judgment was handed down in public, the arbitrators' names were often redacted. And that was in some ways to spare them blushes. But that is no longer the position. And for those of you who followed Halliburton and Chubb, you'll remember that when the proceedings opened in the Supreme Court, the first thing the law lords said was, well, hold on a minute, why is this arbitrator's name redacted? So they raised the point, and in recent authorities, they've made it very plain that that will not happen unless you can show, essentially, that the safety of the arbitrator requires the identity to be kept secret. A couple of other quick points. Where issues of confidentiality arise, the default approach under the modern approach is anonymization of the parties' names, but not much more. That often has the effect of a judgment with an A versus B or a B versus C, but a judgment which you can Google a couple of key phrases in the judgment and find out exactly who did what, when, where. So again, bear in mind that anonymization sometimes is to some extent playing lip service to the concept. And finally, but importantly, the courts have recently said that everybody must be very vigilant where both parties agree that a judgment should be confidential. So gone are the days where you can stand up and say, my lord, myself and my learned friend have both agreed with the following redactions, et cetera, the judge will say, well, no, I'm not happy with that. And so again, bear that in mind. And I've cited a case where that point was made plain. So there we go, a couple of tips, but I'll now hand over to Miff.
And just by way of introduction there, well, first of all, Charles, have you ever been involved in a case where the ground for a German postponement was that the family dog ate the application form? Because it sounds like there's been everything but that.
Many times. I simply wouldn't want to mention some of the arguments that have been run, but it really is tough. And the most recent case I was involved in, STA versus OFY, Mr. Justice Butcher was faced with a whole host of excuses, and he cut through them very quickly indeed.
Thank you. My family, we've had 25 years worth of experience or thereabouts of the Arbitration Act. We've heard that in this area, the number of challenges is reducing. The proportion of successful challenges is very rare. Does that mean we've got the balance right, or is there scope for reform?
Well, it's a very good question. And hopefully one that we might be able to answer today, but we'll see how we go. So I think in the timeline of where we are at the moment, the Arbitration Act, its 25th birthday this year. And in legislation terms, I think a few people are saying it's looking a little bit long in the tooth. The Law Commission earlier this year placed a review of the Arbitration Act on its list of ideas for reform. And the aim of its inclusion would be to maintain the attractiveness of England and Wales as a destination for dispute resolution and the preeminence of English law as a choice of law. Now, I think it's always important to constantly strive to improve our laws and also to ensure that England is the preferred seat for arbitration. And I think it's equally as important, if we think about it, just in the international arbitration community, to ensure that we are seen as a jurisdiction not to be resting on our laurels. So really, 25 years, it's as good a time as any to have a look at the Arbitration Act. But I would say, and this is probably going to preempt what I am about to go into more detail with, that change for change's sake is not always the answer. So let's have a review, but if the outcome of that review is that no reform is necessary, then I think that we are still obliged to announce that with as much fanfare than if there had been a reform. To let the international arbitration community know why the Act works and why it works well. But with respect to the narrow question before me today, as you've probably now guessed, I would argue that the Arbitration Act, at least with respect to challenges and appeals, works well. I think it balances well the need for finality and party consent in arbitration, along with public policy concerns, and by providing limited recourse to the courts where there is injustice or risk of injustice. Now, I've got a very limited time to speak, so I will focus on two potential substantive reforms. The first is the potential abolition of Section 69, and the second would be to change the parameters of Section 68. So if we go first with the abolition of Section 69. Now, England is one of very few jurisdictions that allows appeals of arbitral decisions on points of law via Section 69. And I note here an important point, that it only applies when the substantive law of the arbitration is English law. So some purists would argue that this indicates that England is not as arbitration friendly as other jurisdictions, as it promotes court interference and infringes on the finality of arbitral awards. Now, if we take Singapore as an example, last year Singapore reformed their International Arbitration Act, and they considered specifically whether to incorporate a section that was equivalent to Section 69. And ultimately they decided not to, preferring instead the finality of arbitration awards. However, in defence of Section 69, I think there are a few points to be made. So the first point is that the circumstances in which a party can bring such an appeal are incredibly limited. So an appeal under Section 69 can only be brought by agreement of all of the parties to the proceeding or by leave of the court. And there is a strict criteria to get leave from the court. So this is set out in subsection 3. And essentially, the question needs to be it needs to substantially affect the rights of the parties. The decision of the tribunal must be so obviously wrong, or one of general public importance and at least open to serious doubt. And in all the circumstances in that the parties have agreed to arbitrate the dispute, it needs to be seen as just and proper for the court to determine the question. So it will probably come as no surprise to anybody in this room that the courts have applied this criteria very strictly, and the right has been rarely utilised or been successful. So, for example, there's only a couple of successful appeals. I think there might be one more that went through the commercial court in 2020. Now, the second point, and this is a really important point, is that Section 69 is optional. So it's not a mandatory provision like Section 67 and Section 68, and parties can and often do contract out of Section 69 by providing in their arbitration agreements that no appeal on a point of law is allowed. And even so, rules such as the ICC rules, the LCIA rules, they operate to waive recourse to Section 69. So I'd argue by ensuring that this provision is optional, it actually upholds the party's choice and consent in arbitration, as it will only apply if the parties choose not to exclude it. Now, the third point I want to make here is that also tied to party consent, and that is to do with upholding the law which the parties chose to govern their arrangements. So as we all know, and particularly in commercial arbitration, parties will have chosen carefully which law they want to govern their affairs. And if that is English law, with English-seated arbitration, then the option to have recourse to Section 69 could provide some comfort that if the law in the arbitration has been applied so incorrectly that it meets the strict requirements for leave for appeal under Section 69, that they would have the option of recourse to the courts, in effect ensuring that their choice of law is upheld. Now, if this section is to be reviewed, I think there's a couple of points that we could make. The first is consider perhaps changing it from an opt-out provision to an opt-in provision. So this would counter any concern about the unwitting party consenting to court interference when that was not desired. And the second point ties to the confidentiality point, which is perhaps to provide for a greater degree of confidentiality in relation to the appeal process. Now, I've mentioned this as a potential reform. However, I think in reality, most comparable jurisdictions have the same degree of transparency in their court system. So I'm not sure that that particular reform would actually do anything to make the Arbitration Act more attractive, but I'll leave it there for discussion later. So the second point to make is whether to make it more lenient or strict to challenge an award under Section 68. So we've already heard from Kate how strict the approach is to Section 68, and the Commission has suggested perhaps whether we make it easier to challenge an award. Now, I think that one of the most attractive and distinguishing features of international arbitration is the finality of the awards and the certainty that comes from that. And when you compare the Arbitration Act and the English court approach, it's not particularly out of kilter with any other jurisdiction. And I think if we were to make it easier to challenge an award under Section 68, if anything, it would probably make England a less desirable seat for arbitration. The question would then become, should we make it more difficult to challenge an award? And I think based on what Kate has said, that would be quite difficult indeed. And I think that what we have seen through going through the case law is that there is quite a good balance between the finality of arbitral awards and the autonomy of the parties and the consent of the parties, with a very, very, very limited recourse to the courts in circumstances where there really is a great howler of an incorrect decision. I think Kate's talk really kind of sums that up. So I'm conscious of the time, so it won't surprise you that in conclusion, I think that the review of the Act is welcome, particularly given that it is 25 years old, but I do not think that reform is needed with respect to challenges and appeals. But I do think that if we are going through this process, and that is the consensus and that is the outcome, that it is incumbent upon English practitioners to let the rest of the international arbitration community know that, so that they know how the Act works and why it works well.
Thank you very much, Mifamwe. In an act that might be described as courageous or reckless, the London practitioners have allowed a practitioner from Paris to have the last word on this subject. And as we fasten our seatbelts, Shap is going to tell us how it could be done better elsewhere.
Thank you, Nigel. A few weeks ago, Australia bailed on a submarine contract with France worth 66 billion, choosing to work with the UK and the US instead. My presence here today at an event organized in London on a panel composed of English and Australian lawyers only testifies that we, the French, are not resentful. All jokes aside, I would like to thank 20 Essex for inviting me to speak at this conference, to provide a French perspective on challenges to awards and if improvements can be sourced from the other side of La Manche, also known as the English Channel. I have to say that I heard things today that show that French law and English law are actually very similar in certain respects. There was the confidentiality issue that Charles described, and we've got the exact same thing happening before the French courts. Decisions are rendered in the name of French citizens, and therefore the French citizens have to be able to, see what's being decided in the French courts. Also, Kate mentioned the ZCCM investments holding case of 2019, according to which, in determining whether a decision made by a tribunal is an award, the court should take into account several factors, including the substance of the decision and whether a decision disposes of an issue submitted to arbitration. Well, a similar approach applies under French law since the Sardi Sud case of 1994, in which the Paris Court of Appeal held that awards that may be subject to set-aside proceedings are decisions whereby arbitrators dispose of an issue definitively, in whole or in part. French and English courts therefore adopt very similar criteria in deciding whether a decision of an arbitral tribunal is an award that can be the subject of set-aside proceedings. However, we all know that if there are two countries that have a love-hate relationship, that's England and France. They fought each other for centuries, the 100 Years' War, the Napoleonic Wars. Thankfully today, the only battle between France and England is the battle of the seats. One of the most important factors of any international arbitration is the location of the seat of arbitration, because as you all know, the seats will determine which courts will have jurisdiction to hear annulment proceedings, which will thus impact the scope of review of the arbitral awards. Paris has always been one of the major arbitration hubs, mainly because it's been the home of the ICC since 1923. France has also consistently fostered a pro-arbitration policy, reflected in its advantageous legal framework and arbitration-friendly court system. Recently, it even set up a specialized section composed of 3 judges within the Court of Appeal in charge of hearing challenges against arbitral awards. What about London? Ironically, Brexit may increase London's attractiveness as a seat, potentially to Paris's detriment. Unlike the European counterparts, London will not be bound by the ACME decision, according to which investor-state arbitration under an intra-EU investment treaty is incompatible with EU law. But the attractivity of London as a seat can still be increased. Based on my experience as a French lawyer, I have identified 3 points that, where there may be room for improvement. So the first one is the relationship between arbitral tribunals and courts, which should be increasingly based on complementarity rather than on confrontation. From a French lawyer's perspective, the English court's level of scrutiny of arbitral awards may seem a little too invasive in certain respects. In accordance with Article 1520 of the French Code of Civil Procedure, there are only 5 limited grounds under which French courts can annul an award or deny enforcement of an award. And these are when an arbitral tribunal wrongly upheld or denied jurisdiction, where the arbitral tribunal was not properly constituted, when it did not comply with the scope of its mission, when due process was violated, and when enforcing the award would violate international public policy. So under French law, an award will never be set aside or denied enforcement on the grounds that the tribunal wrongly determined a question of law. As Mifenwi explained, the position can be different under English law, where pursuant to Section 69 of the Arbitration Act, appeals on a point of law are possible unless the parties agree otherwise. So Mifenwi envisaged the possibility of reforming this point, and it would perhaps be advisable from a French lawyer's perspective if one wishes to enhance London's arbitration-friendly image. And it may just be a question of image, because we heard from Kate that, it's not so often that these appeals are possible. So it may be just a question of psychology towards other countries, because if that provision exists but it's not really being used, maybe we should, consider whether it would be appropriate to reform it. A second point on which, from a French lawyer's perspective, there seems to be room for improvement of English law is the approach to challenges to jurisdiction. At the 2021 ceremony of the Global Arbitration Review Awards, the Enka versus Chop ruling of the UK Supreme Court won the award for most important decision. In summary, the Supreme Court ruled that if parties to a contract have not expressly or implicitly specified the law that governs their arbitration agreement, then the governing law of the contract will apply. If the governing law of the contract is not specified, then the arbitration agreement will be governed by the law with the most closely connected with the arbitration agreement, which will generally be the law of the seat of the arbitration. From a French law perspective, this is an archaic way of reasoning, which may negatively impact London's attractiveness as a seat. French courts adopt something called the substantive rules approach, known as the règle matérielle. So applying the règle matérielle means that a conflict of law analysis is not conducted to decide whether parties are bound by an arbitration agreement. So French courts don't examine the existence and validity of arbitration agreements under Italian law or under English law. Instead, they rely on the relevant facts to determine whether the common intent of the parties was to have recourse to arbitration. Applying the règle matérielle ultimately leads to adopting a pro-arbitration stance, and that point is illustrated by the Kaut Food case. So in that dispute, it concerned a franchisee, a franchisor, and the parent company of the franchisor. The arbitration agreement was executed by the franchisor and the franchisee. And although the franchisor's parent company was not a signatory, it had been directly involved in the performance of the franchise agreement. The arbitration was seated in Paris, and the franchise agreement was governed by English law. The Arbitral Tribunal applied the règle matérielle to find that it had jurisdiction over the franchisee's parent company, given its direct involvement in the performance of the franchise agreement. The franchisee then sought to enforce the award in England, and in January 2020, the English Court of Appeal held that, since the franchise agreement was governed by English law, the arbitration agreement was also governed by English law, and therefore English law was applied to the issue, and the Court of Appeal found that the Arbitral Tribunal lacked jurisdiction over the franchisor's parent company, and consequently refused to recognize and enforce the award. Meanwhile, the parent company sought to annul the award before the French courts. And in June 2020, the Paris Court of Appeal, applying the règle matérielle, so looking at the facts, dismissed the application and held that the Arbitral Tribunal had correctly upheld jurisdiction over the franchisor's parent company. So that's a perfect illustration of the point that applying the règle matérielle and looking for consent just based on facts rather than on law will lead to a solution that's favorable to arbitration. So I'm aware I'm running out of time, so I'll make my third point very quickly, although it's an important point. A third point on which French law adopts a more pro-arbitration stance than English law is regarding the recognition and enforcement of awards that are set aside at the seat of arbitration. As a matter of principle, an award that was set aside at the seat of arbitration will not be recognized and enforced in England. In UCO's Capital in 2014 and Malicorp versus the government of Egypt in 2015, the British Commercial Court ruled that a foreign award that is set aside at the seat of arbitration may only be recognized and enforced if the judgment setting aside the award had been obtained by fraud, if it was contrary to natural justice or contrary to public policy. And to the best of my knowledge, to this date, the English courts have not enforced an award set aside at the seat of the arbitration. On this issue, the French courts adopt a pro-enforcement stance since the Hill-Martin and Poutre-Bally case of 1994 and 2007, by holding that under French law, the fact that an award was set aside at the seat doesn't bar its recognition and enforcement in France. And more recently, in January 2021, the French Court of Cassation even went further by admitting the possibility of a domestic award annulled at the seat of arbitration to be enforced in France. So this concludes my presentation of possible areas of improvement of English law. Thank you.
Thank you very much, Chap. Tom, I don't know if we've time, assuming you've received any, time for a question or two. I might just say, as you're doing that, that there's in the materials that I mentioned, in addition to the Arbitration Act provisions and the French Code of Civil Procedure Extract, there are a number of cases, the first of which is an interesting Cayman Islands Court of Appeal decision on its way to the Privy Council, which does address the point about enforceability of an award that has been set aside in the seat of arbitration. And the position may be edging a bit closer to the French position, depending on what the Privy Council decides.
With apologies, because we did actually get quite a few questions for this, which obviously is representative of a very engaging discussion with seconds remaining. Despite the low success rate, has the panel seen instances where a challenge is issued for tactical reasons only?
I guess the answer may be yes, but Charles, do you want to have a go?
The answer is yes. Indeed, in the old days, people used to issue Section 68 applications in the knowledge that it would get you an oral hearing. whereas a Section 69 used to be knocked out. You wouldn't get permission. And so people used to piggyback them. And that was the subject of some scathing remarks in a number of judgments. And they've tried to ensure that Section 68s, which are issued for tactical reasons, can be shut down more quickly. And they introduced, I think it must be 5-10 years ago, a streamlined procedure pursuant to which you can try and do this. But the trouble is you can knock it out on the papers, but then the applicant gets another chance to make an oral application against the sanction of indemnity costs. But the problem is, of course, if you're appealing for tactical reasons, you take the indemnity costs on the chin. And therefore, you can end up with a slightly more laborious, tortuous process than you would have got had you just gone for the standard procedure of knocking it out at an oral hearing. But yes, lots of tactical applications.
Brilliant. Well, unfortunately, we're going to have to move on to the next session as we are overrunning, but please join me in thanking the panel for another excellent session. Next up, we have a panel on the future of virtual hearings, hosted by